Okay, hi everyone. Hey, I'm Heather Burke, an attorney out of Nevada City, California, and I'm here with Omar Figueroa, an attorney in Sebastopol, California, in his office in Sebastopol. So today we're just going to do a quick blog about the federal marijuana issue and how that's going. So Omar, Attorney General Jeff Sessions was recently confirmed by the Senate. What does that mean for marijuana growers in Northern California?
We have yet to see, but it could mean increased federal enforcement. It could go from the federal tolerance that we've seen under the Obama administration, where getting busted, there's no rhyme or reason to it, but it happens very infrequently. And there are now storm clouds on the horizon. And so, the storm clouds could pass by and they could be the same federal tolerance. We could also see federal asset forfeiture. It could either be active federal asset forfeiture or just landlord letters to basically warn away landlords from renting to cannabis establishments and thereby further preventing the what would enable a local jurisdiction to give local permits. They want the consent of the property owner. And so if these property owners are receiving landlord letters, they're not likely to take that risk of federal asset forfeiture for which they have no defense once they're put on notice with a landlord letter. And so that could be another tactic. Another tactic could be the equivalent of a landlord letter to a regulator letter saying, much like the federal government sent to the city of Oakland back in 2010 when there was ideas of Proposition 19 and large-scale commercial non-medical cultivation. The federal government sent threatening letters to the city of Oakland saying you could be liable for conspiracy and aiding and abetting, and that really put a chill on local regulations.
I did not know about that.
And they did the same for Mendocino County, where the federal grand jury started subpoenaing Mendocino County for their cultivation records for their 9.31 program.
I do recall that.
And then that sent shockwaves of fear, and it also dissuaded growers this time around from registering in the 9.31 program because before those same records have been subpoenaed by the federal government. And there was an attempt locally to try to build in some protection that it's confidential under the local ordinance, but to the extent that local ordinances have a lot of independent significance in federal court, it's a very small significance. The federal courts are not going to defer, to local ordinance that says the records are confidential. They believe that they can use them for federal prosecutions. What were you saying about Placer County?
In Placer County, the United States Congressman, the representative for our that district, sent a letter to the Placer County supervisors on putting a chill on their ordinance scheme that they were going to issue, and that's why there was that big pendulum swing back in Placer County. Did you hear about that?
No.
Yeah, that's because the federal representative Doug LaMalfa reached out and said this is very illegal. Don't do it, and they didn't do it.
Just a representative.
It was just a representative, but there was enough heat from the conservative community backing it and the law enforcement community there that they swung back based on that. But it seems like Placer might actually give some small type of cultivation permits, is the last sort of rumor that I heard.
That is true. I think that what we're talking about would be the soft enforcement options that are available to Jeff Sessions' Justice Department.
Right.
The harder options would involve very aggressive asset forfeiture and just going after the money.
Right.
Basically saying you can work all you want in this industry. We're just going to take all your money, and that could be a very aggressive but non-criminal justice type of approach. And certainly the federal mandatory minimums and the drug war that Jeff Sessions is enamored of are options that are still on the table. And I think that the cannabis industry was complacent in ignoring the 800-pound gorilla in the room, basically an existential threat to the industry for all these years of the Obama administration, thinking that this pendulum was swinging in the right direction. And I keep thinking about all of the cannabis law reformers who said back in the 70s, we were certain it was going to be legal. And now it's, I don't know,
legal.
Somewhat legal, legal-ish,
Quasi.
Yes, quasi-legal, semi-legal, or as a prosecutor here in Sonoma County calls it, a moderate increase in decriminalization. And
Right.
I think that's a better explanation of the effects of Prop 64 is that it didn't legalize cannabis. It just basically deprioritized it by turning it into a misdemeanor, meaning that the cops, they're not going to get like those big points that they do for a felony. It's not going to be the rapid path to becoming a detective is solving misdemeanors.
Right.
And that does change the enforcement. I think that, cops are now looking for facts that can elevate an ordinary cannabis misdemeanor into a cannabis felony. So for cultivation, that's going to be bad hippie growing techniques, environmental destruction, waste discharge, killing wildlife. For possession for sales, that's basically anybody under 21. And then for distribution or sales, anything going out of state or people over 21. That's a very reductive simplification, but it basically captures the way the law has changed.
Do you think that the growers in Northern California who have obtained permits, like in Mendocino, Humboldt County, Calaveras, tentatively may still be able to keep their permits from last year? Yolo County, Trinity County is now given a few, and several others. The growers or the distributors who have local permits, do you think that they're going to have any greater protection from federal enforcement than does the unpermitted growers?
I think there's going to be a distinction between having permits from the local city or county, the local municipality, and just having articles of incorporation and a seller's permit and the other types of documentation that I like to call magic paperwork
Yeah.
because it's not really a local permit or local license or local authorization under MCRSA or ALMA. And so the feds will probably stay away. Who knows? There is no rhyme or reason to the Trump administration, and you can't really rely on what Trump has said before for what he's going to do.
Right.
And so maybe there could be a crackdown by Jeff Sessions, and then Trump senses the outrage and then sends a tweet saying medical marijuana is good, but it should not be used for fun. And then that could just completely steer the federal enforcement. And so I totally see it unfolding like that, like no initial direction from the Trump administration. Jeff Sessions does what he does, and then he's held accountable to the extent that Trump reads about it on the cable news, and that's his source of information. He's ignoring all the national security briefings and all of the policy nuance, So basically, he's whatever's on the cable news is.
So basically, the federal difference between permitted and unpermitted by your county or your city is up in the air. How about the difference between Prop 64 conduct and medical conduct? Same thing?
It's pretty much up in there, except for Rohrabacher Farr, which may get extended as Rohrabacher.
What is the Rohrabacher Farr? Can you explain that?
Yeah, that's a spending amendment that basically prohibits the Department of Justice from interfering with state laws in states where medical cannabis is legal. And it's been interpreted by the U.S. Justice Department to mean that they can't go after regulators. The Ninth Circuit Court of Appeals said you can't go after individual defendants who are in strict compliance with state law. So you now have a quasi-medical defense in federal court. And we don't know what the remedy is in federal court because the Ninth Circuit McIntosh case remanded a whole bunch of related cases back to the district courts for further proceedings. And so we have to keep track of what happens in these further proceedings. And hopefully in one of these further proceedings, somebody will be successful and assert that their conduct was in strict compliance with state law, successfully assert a medical defense in federal court. That would be precedential or unprecedented, I guess. And I guess if it gets appealed and lost, it would be precedential. But I think that it's an exciting time to be a lawyer. For us, we may be some of the first lawyers who have an opportunity to defend federal case with strict compliance with state law medical defense. And that's awesome. Ooh. So as lawyers who are addressing, growers, we would say strict compliance with state law. Make it easy for us to defend you. Give us the ammunition we need so that when we're in federal court, we can unload on the federal government using Rohrabacher Farr.
If we could sum up what that ammunition is, what we need from our grower clients in order to be able to defend them if there is a federal prosecution in like 2 or 3 sentences,
Well,
What is that?
definitely you have to show that you're medical, that there's no diversion, that there's no other drugs, that there's no out-of-state distribution, no firearms. I think you get the
What about nonprofit?
Nonprofit, under current conservative interpretations of state law, that is something you want to be able to show that you're nonprofit.
And how could a grower show that?
Well, the easiest case would be like the trustafarian grower who has an independent source of income, doesn't need to rely on cannabis in any way for their income. I have clients who are, full-time mechanics and they have a second cannabis vocation, but if you have an independent source of income, then it's pretty easy to show that it's not profit. But if that's your only source of income, it's difficult to show to the satisfaction of a prosecutor that there is no profit being made, because they think anytime you make more than a loss, you're profiting. And many times law enforcement confuse revenue with profit. So profit technically is revenue minus expenses. Money coming in minus all your expenses, and whatever you're left with, that's the profit. Police think that money coming in, revenue, gross revenue without calculating expenses, that's profit. And many times they find cannabis or they find money at a marijuana grow, because there's no banking for cannabis businesses. And they will find the cash, and they'll say, oh, that cash is profit. Look at all that profit. And really, the cash is intended to pay for all the expenses. It's rent money, it's utility money, it's equipment and supply and new money. So
what about if the grower were to, say, work with a CPA or on their own, do a detailed accounting evidencing that any extra money goes back into the business?
I think that would be helpful. That could also be a template for a ready-made federal prosecution. So if those amounts were significant to trigger mandatory minimums, then they could get the feds very excited. And the thing about the federal law is that it's so broad. It encompasses conspiracies, and conspiracies can last for years. And so they can charge somebody for the entire conspiracy and every grow associated with that conspiracy, as opposed to just one grow. So sometimes there's talk about mandatory minimums, and sometimes I get asked, what if I have like 598 plant gardens? Is that how I can avoid the mandatory minimums? And that is not the way to avoid it.
The answer is no. You can't avoid it like that. Okay, two final questions. One of the questions is, I heard that the White House press secretary gave a statement recently that marijuana, they weren't going to be too harsh on marijuana. What have you heard about that statement about Sean Spicer and any statement related to marijuana?
Yes, so the Joint Blog reported that Sean Spicer said that it was unlikely that the Trump administration would go after medical marijuana or after cannabis in states where it's legal. And I don't think it was limited to medical marijuana.
Right.
And it was attributed to a reporter who doesn't exist, and now the Joint Blog is saying, well, it was really a pseudonym, and now they've added that it was a pseudonymous person. But Tom Angel contacted Sean Spicer directly, and Sean Spicer said, Tom Angel, this never happened. And so a lot of people in the cannabis industry are like reading tea leaves on mud to try to figure out what's going to happen. And this was like a really dose of optimism that a lot of people ran with, and it was widely disseminated. Yeah. And they were saying, see, the sky's not falling. You guys are just, overreacting. Everything's going to be okay. And now it turns out that if Sean Spicer made that statement, he's backing away from it now. Or maybe it was an off-the-record statement, or, maybe he didn't make that statement. Maybe it was wishful thinking. But at this point, if the, press secretary under fire is not willing to say that medical marijuana is okay, or to make some sort of nice statement about will it respect states' rights,
right?
Then that to me is like it sends a signal too.
Yeah.
That when given an opportunity to address the issue, Sean Spicer basically said, "No, I didn't make any." Cold comfort, half reassuring statement about, it's unlikely we're going to bust marijuana.
So, my final question to you is, do you have anything relating to the federal government and Northern California marijuana growers that folks in Northern California should know?
you should be very aware of where the Eastern District of California ends and where the Northern District of California begins, and the counties in each district, because we could see a return to the disparate enforcement in California's 4 federal districts, where traditionally the Northern District of California, which is coastal California all the way to Solano County, Solano County is in the Eastern District. Yeah. But basically coastal California is much more liberal than the other districts. And then the second most liberal is usually like the Central District of California, then the Eastern District of California, which is like the Sierra Nevada, Lake Tahoe, and Central Valley area, which is huge. It's the biggest district.
Okay. Mm-hmm.
And so in the Eastern District, traditionally there have been like very harsh and draconian prosecutions.
Right. Some of the biggest California federal cases have been out there. Molly Fry.
Brian Epis is another.
Yeah, that's right.
All these landmark federal, cases where martyrs were minted in Sacramento and Fresno. Luke Scarmazzo is still serving time.
Oh, right.
And so, because of that, I think that you should be very careful of where you are. Definitely don't go out of state. That would just be like an easy way to invite federal prosecution. And then having firearms, I understand all the Second Amendment rights that people feel strongly about, and the fact that you can't get effective police response if you're living in a rural area, but generally they don't understand that in federal court. Right. And so guns are really something that gives a federal prosecutor tremendous leverage over a defendant, and having no guns present at all deprives the prosecutor of a lot of the tools that they use to railroad people. So I would say no guns.
Okay, no guns too. I actually have one final question, for real this time. And is there any hope on the federal forefront?
Absolutely. The hope is that Rohrabacher Farr will get extended. There's word that it's going to be extended as Rohrabacher Luminar, and more details on that. Apparently, there's like a new rule that they can't be adding new pork to new spending riders on new topics. Right. But the old topics get to stay. And luckily, Rohrabacher Farr is one of the old topics.
Thank God.
And so it looks like that might get extended past April 28th, its current expiration date. So I would say for those who want to be very conservative, stick to the medical side for now until we see what kind of signs the Department of Justice will be making. And, at the same time, keep watching the Department of Justice and keep putting pressure on the Department of Justice, because, if there's no pushback, there's going to be a lot of movement. Mm. If they feel that this is a core issue that the constituency that will generate an uproar, and that will be a bipartisan uproar that will, get the fury of individualist conservatives who believe in liberty. I'm an extreme libertarian myself. And it will also capture the outrage of people who are more, left empathy oriented, which I am too, we admit, then I think that will keep the feds at bay. If they think there's going to be a huge outrage and people, flooding their congressional offices over medical cannabis, then that's what will keep them away.
So is that something we can do? Flood their offices with marijuana positive messages?
Absolutely. I think that every California Republican needs to be hearing from their constituency on that issue. And you living in the Sierras are uniquely situated because your representatives tend to be more conservative than the rest. We don't need to persuade all these Bay Area liberal Democrats, that cannabis is okay and ought to be protected. The people who need persuading in California at the political level are all of these, what do you call them, like more inland, right. Inland California.
Like Doug LaMalfa, who successfully turned Placer County's regulatory scheme around.
Yes. And
so if you want, Americans for Safe Access is having their national conference in early April in Washington, D.C. As part of that, there's a chance to lobby our congressional representatives while we're there, and go on the Hill and actually lobby in Congress. So if you can, it's really important. It's going to be right before the Rohrabacher Farr is slated to end, which is April 28th. So those are huge dates to keep in mind. If anybody wants to join me, I will be in DC that day. You want to come?
Oh, thanks. I need to start a GoFundMe.
Yeah. All right. Thanks, everybody. Thank you, Omar. We appreciate it.
Okay, thanks.
All right. Bye.